Nothing crazy is going to happen. This is just like the Supreme Court arguments. It's going to be very dry. It's going to be very academic. And there's going to be a lot of discussion by Mark Randazza, who Nick has retained, and by David Schneider, who Monty's retained. Those two guys are going to be doing all the talking, and they're going to be talking with the judges. It's going to be a 3-judge panel, so that's what we're looking at there.
Hello, everyone.
Um, there is also one thing I do want to say. I can't guarantee you for sure. We might lose the feed. We called this morning to make sure everything was still on, that they hadn't changed anything. Dates were still good because it did snow out in Minnesota and Wisconsin earlier last night.
Oh dear,
They
we don't
indicated,
want that.
though, when I called, the lady said, "Oh, by the way, if everybody shows up and is present, we turn off the Zoom." And that's so, like, I don't get the point of that because don't we want public access to sports? So I said, okay. I didn't question her. I'm like, okay. So if they're there, they might turn it off, and I don't know. I forgot to mention this earlier. They might turn it off, which I'm kind of like, okay. So it might not. All right.
Oh,
So we'll
that
have
is
to just see
super
what
weird.
happens
Why
there.
would you turn it off?
Walter, and if that happens, guys, I promise, if that happens, the recording of it will be available by 5 p.m. today, possibly.
Oh, well, at least
The
we'll have
past
a
couple of days,
recording,
looks like they get them up
and I'll react to that,
the
apparently.
next day at the latest. So we'll be able to go through it at some point. It just might not be today. Worst case scenario. But we still will get to go through it. Walter Malone for $1.99 says, "I wish you 1,000,000 likes and subscribes." Thank you. Mr. Squiggles says for $5, "Yana, we the jury find everybody gay." Nice podcast, stupid, is for $2 saying, "Does Nick need to go to rehab?" That's his own question to decide. Like I said before, I wish nothing but the best for Nick, and I truly mean that. I hope whatever's going on gets sorted out. But I hope that way for everybody. I mean, this is the internet. I mean, unless you're a communist, then I hope you fall out of a helicopter. The Buzz CJC for $10. Thank you. I appreciate it. It says, "It's maybe a dumb question, but what is your early opinion about the case due to the fact Nick can basically show Monty's own recorded content and prove almost every claim that's being called defaming?" Like I said, Buzz, I don't want to comment on it because I got to be careful because I'm in like the first paragraph of Monty's complaint. I'm kind of a fact witness. I don't really want to talk too much about the case. I'm not trying to do that to screw with anybody. I just think, in a professional sense, as like being a decent witness, I should stay out of that. I think, if you want to make a good, educated decision about what you think
There
the
seems to be
things
a
are
lot of
currently,
buffering, and I'm not
just
really
look at
sure
what's
what to do
going
about
on.
that.
I mean, there's multiple defamation cases you can look at to see how parties have handled X, Y, and Z. And I don't want to. I hate giving an answer like that because normally I love giving
How
answers
about with the
and
quality?
telling you what I think. But this is not. This is not one of them.
See what that does.
I mean, at the end of the day, it could just end up being my connections. I'm noticing that my audio also sounds terrible.
And I can't hear Sean anymore. What the hell?
legal fees just like the accused in the Vic case did, or does he lose the legal money either way? Well, you do have the right to, he has the right to file a countersuit, although at that point this ship has sailed, file counterclaims. But if he were to be victorious at trial, he would have the right to ask for attorney's fees. I mean, will he get them? I don't, part of that becomes as an issue. Is this a frivolous case? Is it questionable? Is there any sanctionable conduct? I mean, generally speaking, even if he wins, probably not. It really depends. I don't know Minnesota law, though. Maybe he could. Maybe he would be entitled to him upon just merely motion and a basic showing. But certainly he could try. But then it becomes an issue of like how much money does Monty have to pay that back? Let's say Nick wins and he gets like $150,000 in attorney's fees. Court says, fine, here you go, Nick. Here's a judgment for $150,000. Well, now he's got to collect it. So then that becomes a whole nother story. It's a whole nother story. Shadow Prime says, finally caught you live. Keep up the good work, Sean. Found you through the Nick's channel way back and really enjoy your content. Well, thank you. And I appreciate the super chat very much.
I wonder what time it actually
Duncan
started.
Idaho says poo poo pee pee. Yes. Yes, all poo poos are pee pees, but not all pee pees are poo poos. Lord Azerman for $5 says, no matter how this turns out, remember to laugh and have fun. Sean, I'm so sorry for the shower calls you'll get tonight. Well, thanks. 989 people here. Guys, and like I just said, we go on. Well, actually, hold on. Are we? Wow, they're running a little late, it seems like, in court, because it said 10:05 they were starting, and it's 10:04, but they might not have the stream depending on how things are set up. We called to confirm this morning. Well, you guys we're going fast now. Holy cow. Agent Road said late's on brand for Nick. Well, right now it's the court. I'm very, usually appeals courts are like boom, 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 boom. They don't screw around. They've got stuff they got to do. It's very quick. It's very
late is pretty.
Yeah, running a little behind. Actually, I'm surprised, but I do think they did have some snow and crap out west, so that in Minnesota that could be an issue. IU is saying, what's a summary of this case for someone who hasn't paid attention to Nick since last year? On the farms, there is a actual dedicated page to the entire lawsuit because it's under the LolCow and LolCow LLP part of the farms.
There's an entire thread for this lawsuit.
It's very well detailed. Downward Forward Punch has rough estimate today on how much this is costing Nick. I mean, it's going to be a couple $1,000s. I mean, easy. It's a couple $1,000 to do an appeal, like writing out an appeal, and then a couple $1,000 more to argue it. Like, yeah, this is not cheap. It's not like he double his cost yet, but I mean, I can easily see this being,
Nick wishes everyone $1 million.
Like $15,000 for him, because also Randazza charges a lot.
Money isn't that big of a deal.
His time is very expensive, so I can see this being like $10,000-$15,000. It could also be less. Duncan Idaho for $5 says, how could Monty, thank you, by the way, saying, how can Monty not have any money to pay damages but have enough to maintain endless, vexatious lawsuits and legal representation? Well, I don't think he's ever been declared vexatious, but how does he have money? I mean, you can always do like things like kind of like Acer Norm, where he files in forma pauperis and gets fees waived, things like that. But generally speaking, it's not a high bar to file lawsuits. It's only a couple $100, generally speaking. So as far as whether or not Monty has the kind of money, let's say Nick wins attorney's costs, well, that's it. Just if he does, he does. If he doesn't, he doesn't. So I'm starting to get paranoid that there's a hold on here. I'm getting nervous like there's another Zoom link somewhere. So, hold on, guys. All right, guys, sorry about that. We have 5 more minutes, it sounds like, here, so that's going to be the issue. But as far as like in this case, Duncan, I think you're saying, well, if I don't know how much Monty and his attorney have paid. I don't know. There's no requirement we ever get to know that. This attorney might take the case on retainer, or a contingency, and that he gets a cut of whatever is recovered. I mean, I don't know what the status is of that. There's a bunch of different ways arrangements can be made with the attorney, so it's who knows how they're working it out. All we know is they've worked it out because they're working together. So. Pike is saying, what is a slap versus an anti-slap? A slap is a strategic lawsuit against public participation. So, for example, we've been talking about like in the Afro Man case. Afro Man made fun of the cops who broke into his house because they did. They burglarized his house, claiming they had a search warrant, which appears to be bullshit. And he made all the songs making fun of him when they sued him. And that was meant to be a lawsuit against his public participation. It's a lawsuit strategically designed to chill speech. And that's what those are called. They're called slaps. Well, anti-slap statutes allow you to attack these preliminarily and kill them off at kind of like a stand your ground situation. It allows you to short circuit the entire court process and kill a lawsuit or kill a cause of action early on before it becomes too burdensome for a party. Because otherwise, with slap suits, big companies could sue little people out of existence by just wrapping them up on legal fees and forcing them to do whatever they want. Anti-slap allows you to short circuit that, and a court can make a determination saying, no, this is exercise of free speech. You can't silence it. Because at that point, you're now using the government to enforce, censorship, and that becomes an issue. Same reason why racial covenants can't be enforced over selling land, because now you're using the court to enforce racism, and that's against the 14th Amendment. Through the 14th Amendment, they can't do that. So, lawsuits are expensive. Very true. And I'm not joking. When you do a lawsuit, you're taking a pile of money.
Well, Nick often says
you light it on fire.
The process is the punishment.
And then you hope you win. But if you win, you might not get any more money.
Nick
you might just get a pile of ashes.
Really?
You also might just get $1.
Gives this Monty Graph.
You might get a little bit of your money back. You might get, you might break even, or you might get a little your money back plus more. That's what a lawsuit is. When you want to endeavor to go on one, I've said that before. That's what a lawsuit is. You're literally gonna light your money on fire, and then you're gonna go shoot dice. Is Nick gonna be there? It's not guaranteed he'll be there. He doesn't necessarily have to be there.
He's been so sick.
Monty ran a GoFundMe for the appeal, yes. But I don't think it was for the entire lawsuit. I think it was just for the purpose of the appeal. But I'm assuming whatever money's left over, he can use for his lawsuit. Duncan says, I'm declaring him vexatious. Does that count? I mean, sadly, no. The court of public opinion is not enough. Yeah. Let's see here. Wow, you guys are like trying to catch up here. I stole Joe's keyboard. Yeah. Geez, you guys are going here. The Pie Baker says fornicate, marry, post birth abort, Monty Nick or the judge. Well, I don't know anything about the judge at the trial court level. Well, I mean, there's 3 judges today, but I don't really know anything about the trial court judge, so I can't really say much about Judge Fisher. I think that's her name, or Fisher with a C. Oh. But thank you. The Dragon's Treasure for $5. Thank you. Left them speechless. Yes, and you're home for tea and anime. If you like a anime lover and you like tea, the Dragon's Treasure sells tea. POV walks with the roving Cyclops for 5 Canadian loonies. Says, I think Schneider's doing it for free. Local axe to grind with Nick, or a coalition of money and adverse parties are writing checks. I mean, I would argue it's probably more likely he's doing it for free or contingency versus like Monica Rial, Ron Toye, and like Jamie Marchi, and you know, all those people writing checks and conspiring to like, yes, like some sort of guerrilla war. I assume there's that. The first answer is the more likely answer if we're going to be realistic about things. I think that's the case. And hold on, guys. I got an email I need to answer real quick.
Here I am talking on a meeting. I was trying to find myself live in the app, but I can't. But I have to mute myself because of how incredibly shitty my audio is. The noise that you're hearing is my stupid computer running so loud. Because I have really shitty software.
All right, guys. The other one just ended. It is time.
Here we go, everyone. Here we go. Here we go. Do we see Nick? Do we see him? Do we see him?
So, guys, this is kind of normal for how things go in a. Why is this?
Which one is Mark Mendoza?
That isn't bigger.
Is that Monty? No, I don't think that's Monty. I was wondering if that white-haired dude was Monty, but Monty has been in the chat, so that's not possible.
Apparently, you guys can't hear the sound. What the heck? I just had the sound on. What? Why is this not?
You're boomering it, Sean. Stop boomering it, dude. Come on.
You guys cannot hear sound, apparently. The audio? Where's the fuck? Why is this not doing audio? Hold on here. Hold on, guys. Guys, hold on. Son of a bitch, why is this not going? Is it still muted, guys? Are you fucking kidding me?
So strange. I wonder why he doesn't have sound.
Guys, that's my
so
mic.
strange.
It's not on the bottom left there. It's frozen too? Are you fucking kidding me right now? Is it working for you guys at all? Guys, I can't tell.
Sorry, dude, but we got nothing.
It's going to be a second for you to
We got nothing.
You're now on stream. They don't see you.
You might need to go back out and back in for the Zoom because it's frozen.
Zoom is frozen. All right. All right, guys. Apparently Zoom's frozen. All right. Hold on.
No.
Hold on.
Oh, there it is.
What? Is it back? Is it on now? Can you hear it?
Yeah.
I think we might have heard something briefly, but then we lost it again.
All right, guys. We're trying to get back in there because I don't know why the sound's not working. Fucking A. All right. Guys, I don't know why it's not working. Give me a second here.
Go through all of the different.
Wait, hold on. You guys are saying audio's back or what? I'm confused. Guys, I don't know what the fuck's happened. The sound was working before and now it's not working, so this is fucking ridiculous. Let's try it again here. Is it working again now? I know I'm muted because I'm not talking to you guys. I'm trying to talk to someone else. I don't know why it's not working. The video is, then it froze. Well, I don't know why Zoom's being dildo ridden, okay? Fucking AIDS laden.
Man, this is really unfortunate. It's like, you know, I like John and all, and he's having a rough time. Well, one thing we can confirm is that Rackets is not in the courtroom, ladies and gentlemen. Rackets is not in the courtroom. I think he's talking to somebody else trying to figure out how to fix the sound. And he has himself now muted.
Guys, I don't know what the fuck's happened. Because it was working when I set it up there. Open another Zoom call. I don't know what that's gonna do because I don't know why it's not working. Other streamers are having the same problem. Okay, well that makes me feel better. Yes, Zoom is working for Nick. God damn, it's annoying. Try my phone. I'm not using my phone. No, I'm using StreamYard, not Streamlabs. Am I using Zoom in the app? I'm gonna try to use Zoom on. I'm trying to use Zoom at the web address. Let me see if this is gonna fucking work.
Well, I mean, if other people are having the same problem, I'm not sure what he's supposed to do. But it appears that it's actually frozen, so it seems to me like the best thing for him to do would be to stop it and restart.
Okay.
Officer, we need...
I don't know. This is frustrating. We're gonna try again, chat. Hold on.
Well, we're trying again, folks. We're starting and restarting.
God damn it. Let's see here.
Will we actually get to watch a trial today?
I'm gonna try to get rid of the Zoom app and just try to get in through online, guys. Yeah, the Zoom app, I don't know. This shit should not work like normal. There's no sound, I get it. On anybody streaming it? Yeah, that's alright. Hold on, I got a plan. I have a plan. I'm just gonna do it, see if I can get it online. I'm just gonna try it online. Get an app to open
Do
it.
it online and then
It's not. It's
Oh, is that the future Mrs. Potentially Criminal? Because I know Sean has gotten engaged, but I don't know if that's the future Mrs. Potentially Criminal.
Court. Only the substantive rights come into Minnesota. Um,
And so, respondent would still be
Can you guys
entitled,
hear the
even if we
audio?
agree with you,
Yes,
respondent may
yes, we
still
hear
be
audio.
entitled under
Ladies and
Minnesota
gentlemen, we
procedural
have
rules to
audio.
have
Repeat, we
additional
have audio.
discovery prior to a hearing on this motion. If it's true that the anti-SLAPP is applying a summary judgment standard, and in Minnesota we say you're entitled to discovery prior to summary judgment.
if that discovery would change something, yes. But when we're looking at simply matters of law, it's a matter of law whether someone's a public figure. And I think we've established that. It's also a matter of law if, for example, the level of rhetorical hyperbole here would be tolerated under Colorado law. Her decision was flawed in looking at summary judgment because she failed to look through the prism of Colorado substantive law. Colorado substantive law gives a wider berth to speech than Minnesota substantive law in this circumstance.
Council, I want to follow up with on Judge Larson's excellent
Guys,
question,
I don't know
because
about the video. I can't.
What
I don't know
would
what's going on here.
happen
Try
if
joining
Colorado
again.
substantive law applied? In other words, even if the special motion to dismiss under anti-SLAPP law had been presented, wouldn't when there be the possibility to argue, wait a minute, that's premature, because if that is indeed Colorado's equivalent of a summary judgment standard of review that applies, we need to have discovery first before a decision is made. In other words, would Colorado's substantive process, well, procedural and substantive process, be the same as Minnesota's?
The procedure would be different. In Colorado, there's an automatic stay on discovery, which I have not argued would apply here. Here, you would have a presumptive right to that discovery, but upon facing a summary judgment motion, let's say I'm arguing that he's a public figure here, and here it all is, there's no discovery that's going to change that. The only discovery.
Well, now we can actually see faces and things, so that's cool.
Medical records,
Yes, this is Randazza.
I presume.
Mendoza! What's up,
Why
dude?
did they not get that before? You know, you frequently find.
I can't
this
fix
is
the
pretty much
volume,
all I
guys.
do. And I always find when someone's trying to end this case early, the answer is we need discovery. And then the question is, well, what do you need? And the answer is we need discovery. It's just a circular argument. But, you know, in federal court, for example, Rule 56D, you have to at least say what it is you need. And that is this, I think that's the standard. I'm sorry, I'm just going to plead ignorance on Minnesota procedure here. I'm not from here, but every state that I've been in, there has been a 56D equivalent where you don't just say, I need discovery.
Can't go on a fishing expedition.
I don't think you can. No, I think you have to have very targeted and specific discovery when you're faced with a summary judgment motion, whether it's under the auspices of the anti-SLAPP law or simply under summary judgment.
I was only able to connect to 2G for
Thank
a
you.
little bit, and now I'm
Thank you,
connected to
Counsel. You'll have
5G, and
5
oh my
minutes for
gosh, it
rebuttal.
all sounds so
Counsel
much
for
better.
respondent. Feel free to adjust the podium.
Is there a trick to raising it?
There's a,
Button doesn't seem to be doing it. Oh, there we go. Good morning, Your Honors. May it please the court, my name is Christopher Bowman from the office of Madigan, Dull and Harlan, and I'm here today on behalf of the respondent, Steve Quest.
It looks
The
like there's at
sole issue
least
before
two
the court
lawyers
is
on
relatively
Nikki's side.
straightforward. Did the district court err by applying Minnesota law to this dispute rather than subjecting this claim to Colorado's anti-SLAPP statute? Minnesota's choice of law framework is based on consideration of what all today call the 5 Jepson factors, predictability of the results, maintenance of interstate order, simplification of judicial task, advancement of the forum's governmental interests, and if still undetermined, application of the better rule of law. In this case,
Do you think Minnesota law is clear that that's the correct test that we apply to the application of substantive, whether this substantive law should apply in Minnesota? Do you think the Supreme Court has clearly said that that's the correct test?
I do think.
I read I think it's Castillo Alvarez case. I don't know if the Supreme Court has clearly stated anything in terms of what our precise choice of law test is, but
I don't know, as I stand here today, I'm not aware of any Supreme Court case law that directly articulates that in a tort context. This court has said that in the Lohman versus East Grand Forks case. I recognize review was granted, but subsequently vacated by that. So I think it is established that the 5 Jepson factor test is the controlling framework here.
under our court's precedent.
Correct. And in this case, not necessarily in every case, but in this case, that 4th factor, protecting Minnesota's governmental interests, Minnesota as the forum state, so overwhelmingly supports application of Minnesota law as to be, in essence, determinative, compelling affirmance of the district court's decision.
Counsel, I have a concern about that. You argue vociferously in your briefing that that is outcome determinative, but aren't we supposed to look at the 5 factors and the 4 factors in particular and have an analysis of each one versus just saying, oh, this one factor controls the whole analysis. So you don't even need to look at the other ones. This one is the nail in the coffin.
I want to make sure I'm understanding where you said the 4 in particular. Do you mean everything other than application of the better rule of law?
Correct. 1 through 4.
Yes. Again, I think it's a balancing of the at least those 1 through 4 factors. And here, factor 4 weighs so overwhelmingly, and I would submit that the factors 1 through 3 either similarly support Minnesota law, or for the simplification of judicial task is probably neutral. But I don't believe that any of them support application of Colorado's law. So, if you look at 1 through 3 being either neutral or leaning application of Minnesota law, and number 4 being overwhelmingly supportive of applying Minnesota law, I think you reach the same result.
So
Wouldn't you?
Oh, go ahead.
Sorry. Wouldn't you agree that generally the presumption is the choice of law is where the plaintiff resides, and generally the plaintiff files in their own backyard?
I think Minnesota and federal law gives plaintiffs the option to choose the forum, subject to, of course, jurisdictional and forum nonconvenience grounds, which isn't what we're here on today. And then you go through the 5, or really here the 4 Jepson factors, and I think you need to look then at. There was a lot of discussion this morning about how Colorado statute out of the LSS case incorporates the summary judgment standard, and a suggestion that affirming the district court's decision and finding that Colorado's anti-SLAPP statute is inconsistent with Minnesota's Article 1, Section 4 right to a jury trial flies directly in the face of Leyendecker.
Counsel, that's not an answer to my question, though. with
I
all due respect.
apologize, Jerry.
Yeah, my question was, isn't it true that generally there's a presumption that the choice of law is where the plaintiff resides, and that generally the plaintiff files in their own backyard, which would be, in this case, Quest's backyard is Colorado?
I don't know if I would say that generally the plaintiff files in their own backyard. And as for, is there a presumption that the plaintiff's domicile controls the forum? Again, I think is inconsistent with, again, the Lohman case, where you have a North Dakota resident injured by a Minnesota resident. In that case, injured in North Dakota, and this court said, it doesn't matter, we're going to apply Minnesota's immunity statute.
Well, let me put it this way. I mean, my private practice was mostly federal, and we almost always filed in the plaintiff's backyard. I mean, it's very unusual for a plaintiff to file in
Interesting.
the defendant's backyard. You want to be in your state. You don't want to have to incur the cost of travel. There's an assumption that the jury is going to be more favorable to you, and you don't file
I
in
like
the
this judge.
defendant's backyard unless there's a really, really, really good reason. For me, just speaking for myself, the first two factors incorporate the whole forum shopping. You want to avoid forum shopping. This looks like forum shopping when you file in somebody else's, in the defendant's backyard.
And the
of the choice of
Grosney.
law.
I like this
I'm sorry,
judge.
because
I
of the
like this judge
anti-SLAPP
a
law,
lot.
being held unconstitutional, and so there is no anti-SLAPP law in Minnesota, which would be much, much more favorable for the plaintiff here, Quest. Why, under the first two factors, why doesn't that favor then Colorado because of the overriding goal to avoid forum shopping?
I would respectfully disagree that this is an existence of forum shopping. Speaking to my former practice where I practiced railroad litigation, no, we didn't file every case in Dallas, Fort Worth when we were suing BNSF, but where the tortious conduct occurred was controlling. And here, Minnesota is not only defendant's backyard, it's also the forum where at the very least, allegedly, and I think as the court correctly found, defamation per se, in fact, happened.
But how did I think you raise an interesting question of where the harm occurred, because the harm here, unlike the Northwest Airlines case in which the defamation had been submitted in a newspaper, local newspaper, it had subsequently been republished in Texas, but the focus was on the fact that it occurred in the local paper. Here we're now in the 21st century. The defamation occurred on the internet. So how does that play into it? And does Northwest Airlines case even apply, or should we really be looking at the restatement that looks more at the significant, I always forget the name of the significant relations test?
I think, again, I would submit that this court has established that you don't look at
Rackets
the
offenses.
significant test. Minnesota, to my knowledge, has
International.
not adopted that standard.
And
here,
global.
that
And he's an
Minnesota
international
applies
man
the-
of
the
mystery.
five factor
All
factor
hail
test.
Pope
To your question about does Northwest Airlines apply in the 21st century with simultaneous publication, not only nationwide but worldwide, I think also questions then predictability of the results. If in Northwest Airlines, where a statement is made to a local newspaper before local newspapers also published online, I think that in that circumstance, predictability of results leads to a favoring of where the newspaper is published. Now, where you have simultaneous publication globally, predictability of results becomes much harder to square there, because if this statement, there's a suggestion that because this is submitted over the internet, there's then a predictability of Colorado. But to Judge Eid, your question, assuming without conceding today that both of these individuals raised to the level of internet celebrity, that reputation exists beyond Colorado. That reputation exists potentially globally. And then when you have a predictability question, it throws the whole thing into chaos a little bit.
And I tend to agree with you on that. I think it does, which I think makes Northwest Airlines a little maybe outdated. And so this court and the Supreme Court have relied on the restatement for when we're really entering into new areas of law. Isn't that what we're really doing here? Isn't this kind of uncharted territory that we're entering into? And if so, shouldn't we look to the restatement and what other courts have done as persuasive authority?
I don't think the court needs to go that far in this case. The court certainly could. But here, where again, I think the question before the court is whether or not the district court erred, and this court is an error correcting court, it has a limited scope with that. And so if Minnesota were to formally adopt the restatement and say, Northwest Airlines was great for the time that it was decided, it doesn't apply in the YouTube social media era. Respectfully, that would be a decision for the Supreme Court to make as a policy making court rather than this court.
And in fact, to the extent that the Supreme Court has applied the substantial or most significant relationship approach, hasn't that, I think that they pretty clearly said in Castillo Alvarez that they're going to apply that test when the issue has to do with both a procedural and a substantive purpose. And I think that appellant was pretty clear in their argument that they're not arguing the procedural aspects of Colorado law. They're only arguing the substantive purpose of Colorado law, which would indicate that the most significant relationship approach is not what the Supreme Court would ask us to apply.
Precisely.
I have a question. So I think that my issue with factor number one has to do with if your client had filed this claim in Colorado, I expect that your argument would have been, my client lives here in Colorado and this is where most of his friends and relationships are, and therefore his reputation is most harmed in Colorado rather than in Minnesota. And I do think that when you look at the federal cases that are starting to wade into in the internet age, what do we do? In defamation cases, often they say, well, a person's reputation is most harmed in the place that they live. And so is there a reason
I don't know.
why
To me, the questions sound like they're siding with the rackets. To me,
I think
I don't
that
know.
weighs
Maybe I'm
in.
wrong.
Again, I would submit that there is some question about whether or not Mr. Quest is in fact a Colorado resident and resides in Colorado. But for the purposes of this
in the
appeal
complaint, is it alleged that he's a Colorado
today,
resident?
yes, and so for the purposes of this appeal today, I'm not arguing that it's not. We would recognize that Colorado meets that second step of Minnesota's choice of law framework, where there are sufficient contacts of both Colorado and Minnesota for global constitutional perspectives, either forms or either law to apply. Also, this court has recognized, and I think this analysis does survive an internet age evolution of society out of Northwest Airlines, where that first factor has less relevance in situations where they're not consensual transactions, where everybody knows in advance what law is going to apply. When we do business litigation, we put a choice of law in most agreements. So our client, the other client knows, hey, if there's going to be a dispute, everybody's agreed Minnesota or Iowa or Michigan law will apply here.
And counsel, I actually agree with you on that point, speaking only for myself. I think that is a correct analysis. But then the first factor, I think, goes to the underlying issue of avoiding forum shopping then, right?
Well, which I think the district court analyzed as the second issue, or the second factor, maintenance of interstate and international order. I think the district court did in fact find that they thought this was forum shopping and that factor did weigh in favor of Colorado law. Do you disagree with the district court's finding on that?
I disagree that maintenance of interstate order supports Colorado law. I see that my time's almost expired. Do you mind if I fully respond to the question?
And sorry, Judge Reyes, if I restated your question.
I want to make sure I'm answering all the court's questions. So I'm gonna respond to Judge Larson, your question first, and I'll look to Judge Reyes and make sure that I've answered any questions that he has. We would dispute that the maintenance of interstate order factor supports application of Colorado law. The Colorado Court of Appeals, different divisions can't seem to agree on what this statute means and what standard apply. This statute meaning Colorado's anti-SLAPP.
So you're saying there are other cases that have held it's not a summary judgment standard?
Yes.
Okay.
Specifically Salazar talks, give me a moment. I have 522 Pacific Third at 248. That's a pin site for it. But talks about how, the division held the court neither accepts the allegations as true nor determines truth, but must assess whether the allegations and defenses are such that's reasonably likely that a jury would find for the plaintiff. And then you get into almost the constitutional avoidance analysis that the Minnesota Supreme Court rejected in Leondecker 1, that the language of the statute is not consistent with a summary judgment standard. Judge
Yeah,
Reyes,
I would like to, if you'd respond to Judge Reyes's question.
and I apologize, Judge Reyes, would you mind re-asking the question?
Sure, if I can remember it.
I think
I know what it was. It was on the first factor. So I basically, I said, I speaking for myself, I tend to agree with you in terms of, the business relationships and with respect to the first factor, but I think there's still case law talks, the Nodak case talks about you still want to avoid the forum shopping. That's still part of the factor consideration even under the first factor, correct?
I think avoidance of forum shopping, yes, is a consideration in the first factor. I would agree with that.
Okay, thank you.
Thank
Can
you.
I ask a question? I think you were trying to at some point get to the fourth factor. And just to sum up, since your time is done, perhaps you can give us your best argument as to why you believe that factor so heavily favors application of Minnesota law.
Sure, Your Honor, and I will do my best to be brief as the blinking red light grows ever near, or as in fact here. In the Leondecker decisions, this court at first tried to frame Leondecker as a Rule 12 analysis, or frame Minnesota's anti-SLAPP statute as a Rule 12 analysis. Despite the language of the Minnesota statute not being a Rule 12 analysis, the Minnesota Supreme Court said, no, you can't do that. It's not a Rule 12. This court, in fact, recognized, hey, if this isn't Rule 12, it violates Minnesota's constitutional right in a footnote. And I believe it was Judge Connolly's decision in the first Leondecker appeal, or the first Leondecker appeal concerning the anti-SLAPP statute. The Minnesota Supreme Court in Leondecker 2, I believe 2017 decision, talks about how Minnesota has a constitutional interest in affording a jury trial right and submitting a claim to requiring the court to make a determination, which even LSS says that the court has to make under the anti-SLAPP statute, would violate that right. So unless the court has any other questions, thank you, Your Honor.
Thank you. Counsel for Appellant, you have 5 minutes and there's a little shuffling behind you, so
Okay, thank you.
I'll give you a sec. You can feel free to adjust the podium if you don't want it that high.
I can roll with it.
Okay.
So I want to address the what choice of law furthers Minnesota's interests first. Now, Colorado has forged a legal regime that protects its citizens from defamation while refusing to let that value impede on First Amendment rights. Essentially, Colorado has said, you have this much latitude when you're talking about a Colorado
Pull up,
reputation.
guys.
And I don't see how it furthers Minnesota's interests to say that if you're a Minnesota resident, we can strip you
It kind
of
of
that
sounds like the
protection
judges could be on
as long
Nick's
as they come
side
and forum
based
shop
on the
into
questions
Minnesota
that
to
they're
get a
asking.
different result. Should a Minnesotan have weaker rights than a Coloradan when you're debating over a Colorado reputation? I think that you'd be doing the exact opposite of serving Minnesota's interests.
Counsel, can I ask a question? Do you disagree with respondents' argument that Colorado actually hasn't settled on whether it's the summary judgment standard that applies to the Colorado statute or not? And I guess I'll just tip off that where I'm going with this is on factor 3 with regard to the simplification of the judicial task.
Yep.
Are we really going to be sending this back to the district court to have to resolve conflicts in Colorado law here in Minnesota? Because that would seem a challenging task for a Minnesota judge.
It
to
would, but
do.
fortunately, you don't have that problem. His assessment of Colorado law, with all respect, is wildly incorrect, not even close. And the case he cites for that proposition is a California case. So California, looking at the California.
So
anti-SLAPP law.
can you just, so the case that you're citing for the summary judgment standard, can you just explain, is that what we would consider here in Minnesota a precedential decision that's binding on all the courts, or is that, just because I don't think
is.
you cited to the Northwest Reporter. So I wanted to, is that a binding case on all the courts, or is that a non-precedential decision that's more advisory? Because here in Minnesota, we would have a distinction in terms of the weight that we
Right.
would give to that kind of case. And so I guess the case that you're relying on, what is the weight of that authority?
It is the most recent appellate decision out of Colorado on it. So I guess you'd look at it like if you were in a federal court, the federal court would have to follow that. So I don't think we have
The
any.
district courts in Colorado would have to follow the decision that was,
Yes.
okay, thank you.
And as far as simplifying the task, I think I didn't give a very satisfying answer to Justice Eade when you asked me a question. And really, it was so fundamental. The predictability factor, simplifying the task.
All
Remember,
my
there's
cat
all
cares
this
about
discussion
right
of,
now is
well,
whether or not
why
I throw
would
his
you-
toy.
Why would you think that a Colorado reputation would be governed by Colorado law? Well, Calder versus Jones out of the United States Supreme Court made that very clear. Now, that's a personal jurisdiction case, but the reason that personal jurisdiction was in California in that case was because the Supreme Court said, the United States Supreme Court said very clearly, your reputation is where you are. Unless there's some overwhelming reason not to be, like I could see maybe if Stephen King.
Can you remind
lives
me
in-
the year of that case? Is that a case from the internet age? Because I think respondents' argument is that this person's reputation is really on the internet. And so where his reputation was harmed was globally
Guys, I
or
forgot to change
across
it.
the entire United States. And that is his
let's adopt-
reputation is no longer really located in Colorado, given this particular person's lifestyle.
Well, then let's adopt that. Then why not Hawaii law? Why not California law? Why not Massachusetts law? I mean, I think that we have to have some predictability, and that predictability is, when I do pre-publication review for publications, they come to me and they say, we're going to write this story. And I say, where does the subject live? That's how everybody I know who does pre-pub review does it. Says, where are we going to wind up getting sued, or what state law are we going to look at? So predictability, I think at least in the online publication world, would be thrown into chaos in Minnesota if we decided that somebody whose reputation is everywhere, but lives in a specific place, that their reputation should then be managed under Minnesota law. And remember, again, if you sued at home, it would be a different result. So Colorado law needs to apply here unless you would like a different result for Minnesota residents, which again strikes at the core of what Minnesota's interests are. I think Minnesota's interests, if anything, should be that its people are free to speak in the same way that everybody else is, not to say that they're going to wind up getting sued in a libel tourism case by somebody who comes from one of the 35 anti-SLAPP states. And again, to remind you, sorry, I'm done. If you have any questions for me while I'm still up here.
Thank you.
All right, thank you very much. And thank you, counsel.
Thank you to both counsel for your arguments in this case. This case has been submitted and we will issue an opinion in the time prescribed by statute. Thank you.
All right, guys, that's it. Sorry. Okay, so that's it. Finally. Sorry for the delay at the beginning. And let's wait till they leave. Yep, so it's all done. Okay. So that was interesting. That was a very interesting thing. Got a couple of super
Very,
chats that
very
we got to get caught up on real quick here. I forget how far I get. C-Nut Arbuckles for $2 saying, wish you $1 million. Thank you. Chris Clements for $5 saying, how much trouble is Nick going to be for being gay and late to court? He doesn't have to be there. This is just your attorneys show up and do their thing. So thanks for covering this. Appreciate you. No, thank you. Fatty Cat says Nick is paying over $150K. His lawyer says as much in the link I posted. Yeah, but like I said, I don't know for like total sure, but the appeal itself is, its own little cost. Matt Matt Stuffer for £10. Sterling, the King's Sterling. Cheers you and your coverage of this lawsuit. How long till you start toasting grandma's passing? Sarah Marie for £2 sterling says, "Hey Sean, can you give me a TLDR?" Okay, guys, I put it in the description, but yet Monty is suing Nick because he's claiming that Nick made defamatory statements about him, alleging that Monty is a pedophile and has molested children and likes to do it. Nick said it a couple different times throughout 2022 in the fall, and Monty sued him. Nick is trying to claim that because Monty is a resident of Colorado, Colorado law should apply. The issue is Monty filed the lawsuit in Minnesota where Nick lives. So it becomes an issue of the conflict of laws, a choice of laws. And that's a separate, in the law here in America, that's almost a separate focus. There are attorneys who solely focus on making the arguments for which laws apply. Because this is a very big issue in federal courts where you're dealing with interstate defendants and parties that are involved. What laws do you apply and how do you apply them? Well, it's an entire field of law. There's classes in law school solely devoted to that. So it's a very interesting thing to talk about. We'll get to that in a second. Lefty's saying, "Can you play your clip of Monty springing out on you after this is over? That was classic." Yeah, I got to go back and find it, but maybe. Reformed Convict for $2 saying, "For a man with one hand, that fast clacking offends me." My apologies. Scarecrow for $9.99 says, "Google Luis and Peaches Owen. Google the Bob and Celeste Ricada charity. Nick is a libertarian version of Hassan Piker. Streaming is a hard job. You'll never know how hard Nick has it." Yes. As Hassan told us, this truly is. I'm doing God's work right now, and you should be thankful for me.
Yes,
Hollywood
yes,
for
we are
$5
very
says, "Hi,
thankful,
Sean, have
Sean.
shekels."
All hail, Sean.
Easy enough. Scarebro for $4.99 says, "Should have
Doing the
figured out
Lord's
Zoom last night while
work.
playing Squad with Spectre." I know, but it's so much fun playing Squad. The Pie Baker says, "Can we get status on my ADA compliance officer? Have I been treating them better than Nick? What's my current ADA compliance rating?" Scarebro says, "Terrible argument. That means you can violate your own state laws in your own state if your target's in another state." And that's part of, we're going to get to that. The court raised the issue. Okay, Monty, why did you file it here? Because normally you would file it where you lived. This does seem like forum shopping to them. And the one attorney, the one judge who did a lot of federal work says, "Yeah, in my experience, this doesn't seem right. Like, I wouldn't have filed it this way. I would have filed it in Colorado where Monty lives." Or I know there's the issue of, does he live in Illinois or does he live in Colorado? You'd file it wherever the heck you're living at. Going out to go after the defendant like this is a different way of doing it. It's an acceptable way and it's a legal way, but it doesn't always make sense like that. You normally file it in your own backyard. Well, because now it's home field advantage. Agrolef for $2 says he has never lied. Nick Holt saying, "Feels like the lawyer should be arguing that his digital reputation exceeds his in-person one, so having this go down in Colorado is less compelling." Well, here's the thing, though. I mean, based on that logic, you could sue anywhere if your reputation's all over the world. And there's got to be, yes, and for an internet person, and it's like such as myself, there are people all over the world who know who I am. Now, that might be only like 10 people around the world. Still, 10 people. Does that mean if I have a fan that's in Romania, I can now say I want to sue in Romania or Slovenia? Well, no, that would be preposterous. I should be able to sue in Ohio. That's where I live. And then if the guy lives in another state, maybe in another state, but do I get to go to every other state in America? Can I go sue in Alaska? Let's say it was Monty, for example, and we were in Colorado, and he lives in Colorado, and I want to sue him. Would I go to Hawaii and do it? And Red Daza brings up a point. What state laws could I apply then based on that logic? Theoretically, and I think it's a bit of a stretch, but I do agree with the premise, you could apply any state law at that point, and that creates a massive problem. Generally speaking, you file where you're from. That's where the injury happened. The injury happened where Monty is. Duncan's saying that Ricada's attorney's arguments seem much more poised, prepared, and convincing. I don't think so. I think he didn't get as much pushback. That's part of the issue here. I think their attorneys were Monty's attorneys were not anticipating the court buying into the whole forum shopping thing like they did. So I think that threw him off a little bit. And also just that's somehow people speak. That's how they handle themselves. So I know we listen to these and people say, like, oh my God, he sounded shaky. It's like, it's probably how that guy talks all the time. It's probably how he addresses things all the time. If you listen to his other oral arguments, he probably sounds similar. So you got to be careful on the, like, oh my God, he sounds shook. It's like, probably not. Probably not. It's definitely not his first.
But it's
this
so
definitely
much
is not his
more
first rodeo.
interesting and entertaining if you
And then
assume that he sounds
Spasticus
shook.
Autisticus
I mean,
says
come
for
on.
£5, once again, of the King Sterling. Thanks for your
Let's at
coverage.
least
Listen to this
pretend.
on my way back
Yeah,
from an
let's
equity and
pretend that he
trust law
sounded
lecture. Give me your best absurd perpetuities hypothetical. Yeah. And Carrie for $4.99 said, Sean, you did a great job. Thank you. So I think it's very interesting. Josh Moon, if you are the Josh Moon, hi, saying, yeah, Nick wins this. It's going to be split. I don't know. But here's the thing. I brought this up already. Even if Nick wins here, the trial court could say, all right, I'm applying Colorado law and say, nope, this is still defamation. Anti-slap denied. Go to discovery. And then from there, like I said, discovery leads us into interrogatories, requests for admissions, requesting discovery from each other, depositions, all that fun stuff. That can still happen. So even if he wins here, he can still lose. Now, could he then turn around and appeal that decision? Yeah, but he's going to lose on that one because the Court of Appeal is going to say the court likely sets up a nice record for it. It's going to highlight the reasons why it supported its decision. And the Court of Appeals is generally going to go along with it. So, no, trying to appeal that would be borderline crazy. So I think even if Nick wins here, he can still lose. Like I said, his victory leads to two paths. Either he wins when this is applied or he loses when this is applied. And I don't know where that's going to go. I kind of get the feeling the court is not going to be sympathetic to him down there. So I have a feeling he'll still probably lose there. This who we are says, Monty in theory could file again in Colorado. Yes, he could dismiss right now. And he has the right to voluntarily dismiss a case. Although at this point, after doing all this, it's going to look kind of bad. And then he goes to Colorado. The courts might see this as somebody, because they could bring up, look, we just came from Minnesota. This is all a bunch of nonsense. That doesn't look good for Monty at the end of the day. So, no, they kind of made a decision. They're kind of, I think they're kind of stuck here. And Rob for $2 says he filed it in Minnesota because we don't have anti-slap. Exactly. And that was like the name implies, that was a strategic decision. Monty worked out, well, there's no anti-slap in Colorado. So if I attack him there, Nick he can't slap down my slap suit. So that's why he did it. Now, if he goes to Colorado, he runs the risk of losing there with an anti-slap getting applied. But there's still the fact that if it truly is defamation, well, then it becomes a problem. Does Monty initiating it in the chat matter? No. I mean, you can maybe try to argue unclean hands, but did Monty defame Nick really? No, he was just trolling the shit out of him. So you'd have to make arguments there. You could claim like unclean hands or, that he's, for those who seek remedy must have, be free from themselves. But no, just because you initiate contact doesn't matter about what another party does to you. So, for example, if, you commit a tort against me, just because I initiated the whole situation doesn't necessarily excuse your conduct. Sometimes it will, but it's not always guaranteed. Duncan Idaho for $10 says, if Monty had never lived in Minnesota or emailed himself in any way, I think you mean availed himself, and it's AV, availed himself in any way of the rights and privileges of a Minnesota resident, being able to sue in Minnesota from Colorado seems pretty wild, right? Not necessarily, because if you think, the guy said the thing in Colorado, the guy said the thing in Minnesota. Okay, well, I'm going to go take advantage of it there. Well, the tort was committed in Minnesota, and I think you could argue the tort was committed in Colorado. I think there's nothing wrong with going forward and doing that. As Randazza stated, typically though, almost always you file where you live. Or if you're not filing where you live, you file where the defendant lives and you're arguing Colorado law. That's how you would do this. And typically for somebody like Monty, he would go to federal court and do this. But he hasn't. So yes, the judges are concerned there's some forum shopping going on here. And they don't like that. Now, forum shopping in and of itself is something attorneys can do as long as you're not making it obvious. But it's generally something we're against public policy wise. But if it's, they're like, we know what you're doing, but we can't do anything about it type of situation. So do I think it's going to turn into that? I don't know. They were far more receptive than I anticipated them to be, that was a surprise to me. Also, Rob, I'm going to say hello. We're going to have to talk again soon. I know you got a lot going on out there. Josh saying unclean hands, but yeah, and that's the thing. There would have to be a reciprocal action. And there wasn't so far. So I don't think that the fact that Monty engaged with him first does anything there. Just like I said, for example, and if it was me and Legal Vices and I sued him for battery because he hit me. Yes, if I hit him first, he would have a defense to say self-defense. If I just walk up to him and I say, "Hey, Jeff, what's up?" or I start making fun of him,
I love the way that Sean is so patient.
If I haven't committed tortious actions on my own, it's gonna be very hard for him to say, "Well, but Sean." At the end of the day, it says Baldo versus Mellon. Yeah. Yes. Are you winning reality streaming your stream? No, I did not. But hey, hope you're doing well out there. It's been a little while. WR or Dub R. Sarah Marie for $2 or £2 again. Also, is saying is this just trying to run up the bill for Nick? No, because Nick appealed. Nick filed the appeal, so Monty didn't file the appeal. Monty got a favorable outcome in the trial court. The judge said at the trial court, Colorado law does not apply. That's hogwash. We're in Minnesota. Minnesota law applies. So Monty got what he wanted. Nick didn't get what he wanted, so Nick appealed. So, no, the only person driving up the cost right now at this point is Nick. And I'm not saying that he's driving this up frivolously or maliciously. It's just doing an appeal, doing extra steps costs more money. Oh, let's see. Where else we got here? You guys are just chugging along here.
Winning reality is also
Tridio for $5,
stream
by the way. Thank
sniping
you.
him,
Thank you for everybody else's
apparently.
super
That's
chat.
funny.
If I didn't say thank you, my apologies. What if Monty had traveled to Minnesota at some time? He could be jumped by crazy people thinking it was a PDF file, and people are missing the forest for the trees. I mean, you would have to show that injury happening then, but that hasn't happened. Like, what if? I mean, if as an ROTC, and I know you guys are looking at me like, when did that happen? It's like, I was a lot skinnier my freshman year of college, a lot skinnier. As the one of the cadre, Master Sergeant Strange said, if we're a fifth, we'd all be fucked up by now. Yes, there a lot of things could happen, but they haven't happened. And you have to go off of what has happened. The damage to your character. This idea that if he shows up in Minnesota, he could get attacked by a roving band of vigilantes. I mean, is that really going to happen? No. He could, get pelted by a bunch of Kiwi farmers who show up with like melons or something. Okay, that's still pretty much never happening either. I'm just saying you have to show real injuries. Not, oh, this could have been bad for me. It's like, okay, well, Nick Holt saying for $9.99. Thank you, Nick, is saying, how does anti-slap work in the context of defamation per se? What determines a reasonable chance of prevailing if both parties argue on what was said in the jury and the injuries assumed? Okay, well, anti-slap does not get to the jury. Anti-slap is a question of law. The judge decides questions of law. Okay? So anti-slap is you
No matter
challenge
what I
it
do,
and you say,
people's
I have the
super
right under the
chats are
First
covered
Amendment
up.
here to say what I said. This lawsuit is
Sucks.
bullshit, and it gets tossed. And you make an argument, you have a finding, you have a hearing, and the court makes decisions. So with that being said, I mean, if you can show this is public parties and public people involved, okay, and basically you can get away with a lot in an anti-slap situation. So, for example, if you really did commit defamation, you could still, to an extent, get away with it. But here, he's not. Anti-slap does not automatically protect him. I mean, you can commit sometimes too much. If a court determines, no, actually, you did too much of one thing, well, anti-slap does not always apply. Is there a reasonable chance of prevailing if both parties agree on what was said and the injuries assumed? Well, if everybody agrees on what's said and the injuries assumed, it just becomes a question of, was there actual damages? And was there, if it's defamation per se, there's a presumed harm, and then it becomes, what are the damages? So we haven't even gotten that far yet, as far as what the jury would determine, what's being presented to the jury yet. That's still kind of out there. So if you're wondering, does the jury determine anti-slap? No, that's something the court decides, and that's settled way before you get to a jury. And we're not even to discovery yet. So we're at like a half mile into a marathon.
What?
At this
I mean,
point.
according to Nick, like, what would
Monty
discovery
says,
even be?
No, it's not forum shopping. I was in the state of Illinois at the time, and Randazza knew that. Thus lied the court.
Oh!
He had an
Monty
he had an opportunity to make it
speaks.
right today, but failed.
Oh.
Soon he'll be learned. Monty, all I can tell you is everything you say, comment-wise, could be determined to be admissible in court. I can't tell you it would be. I can't tell you it wouldn't be. So I would caution you, and I don't know if your counsels advise you, but I would recommend you consult counsel before you make statements in public regarding the actual factual basis of your case.
Oh my goodness.
Because, and I'm not saying you are forum shopping, but the court seems to think that might be an issue. That doesn't mean they're going to agree ultimately in their opinion, but that's something they're interested in. There's something they're going to look into. And that's the other thing, guys. It's hard to gauge from one side or another what the court's doing because they grilled both of them. They grilled Randazza about how's this going to work? Should we really be applying Colorado? And then they point out, like, this seems like forum shopping to the other guy. So I think right now it's split. I think it'll probably be a split decision. I don't see it being unanimous. And like I said, I think Nick can win, but he could still lose. That's a very real possible outcome. Absent-minded says, that's a funny one. How does this case make it to discovery when there's no damages claimed? Well, that's part of, he did claim damages, and he has damages in his complaint. The specific damages, though, can come out in discovery, although, as Randazza stated, and I agree, that discovery is solely within Monty's possession because Nick has no idea whatever it is he may suffer. And if he suffered mental health damages, pain and suffering and mental anguish, okay, well then, he had to go see a shrink or whatever it is he had to do. Yeah, those are things that Monty solely has dominion over. So I agree with that issue. And the court said that seemed a little weird too at the beginning. While I was trying to get that loaded, Randazza brought that up and the court agreed. And we will go over this with the audio.
I mean, I think Monty is screwed.
Off license says, could this affect Nick's law license? No.
I mean,
getting sued
I'm
civilly and it's not relating to your duties as an attorney generally won't affect your law license unless it's something super egregious that pushes the bounds of just general conduct. Getting sued for defamation like this, no. If he were to go into court and say something dumb or do something dumb, sure. But just getting sued doesn't automatically cause you problems. You do have to report those things, though. Like if you end up getting sued, generally least in Ohio, you generally have to report when like legal action's taken against you. Although and here in Ohio, the Supreme Court look at it and say, oh, it's nothing to do with his legal representation. They wouldn't care. What happens on a split decision? Well, there's 3 judges, so it's 2-on-1. So whoever it's a majority rules. Sweet Tooth is saying, when Monty's saying Randazzo lied to the court be deemed defamation, I mean, you'd have to show damages because it's not actually. I mean, you have to show damages there. Is it really defamation per se? Because is he accusing him of committing perjury? No. So I think you'd have to show some damages there, and how that would work. And
He can have his lawyer
then I think
file
it's
something
in response to a party,
court
and they're in the middle of a suit.
saying that the lawyer lied.
I don't think that
and
would be
Randazzo
really
wasn't
actionable.
lying. But
Shade Chaser says, "Are we
if his
forgetting the
lawyer doesn't
accusation
do
didn't
that,
start with
gee, I
Nick?
can't imagine
Beyond
why.
the issue and appeal, Rackets repeating a rumor or so a decade old. Will that make any effect if it makes it to court? It might. I don't know. That's like I said, guys. That's something I don't want to comment on because I'm involved in this. I got listed as a party in it, and for that, I try to avoid actually talking about the actual merits of the case. Whether or not Colorado law applies or we have to eat ice cream with a fork or a spoon doesn't affect the actual progression of the case. That's why I don't feel like I can't comment on it. And I hope that makes sense there.
I
Is
think
Jim gonna get
personally, Sean
subpoenaed?
is
That would
taking a
be
big
hilarious.
risk by even
They
restreaming it
wheel him in
when he
and he's
has
like
to
in
be
the Darth
careful
Vader
about what he
chamber.
says.
I would show up for that. I'd show up for that hearing. I'd show up for that trial. I'd go all the way to Minnesota for that. Yeah, Alpha Fox, I agree. I'd say that's more of an opinion anyway. If you really wanted to get involved with it, the whole issue of what Monty's saying Randazzo lied. Even then, it's like, does Randazzo feel like he's been injured at all? He's going to be like, no. So it hasn't really hurt Mark at all. So no, he's going to, no real problem there. No real problem there. There's a jury question in the Michelle Troconis trial. I'm not surprised. Tonight, guys, we'll probably do the closing arguments for that case. I think the jury's going to be out a bit because they got fed a ton of bullshit on that case. They're going to have to sort through. Jester saying I'm probably walking a fine line. I don't think it's that fine of a line. It's just, I think I shouldn't be commenting on the case. And it's not because I have an ethical obligation. I feel just as a party, if these guys have been sued each other, like, I should stay out of it. I could comment on it, but then, that gives problems if like Nick were to use me as a witness. Okay, well, I'm biased. If Monty were to call me, that makes me biased. And these things are hard enough when you're litigating them as an attorney and trying to make less problems for the people involved. I don't know. I kind of feel like that's karmic. Trying to pay it forward a little bit and be what I'd want a lot of witnesses to be, somebody who's not fucking around in it too much. Although to be fair, I think, and if I had a case I was pursuing and I found out one of the parties was one of the witnesses was like live streaming stuff, I'd be like, oh fuck. But hey, I'm trying. I'm trying really hard.
I can't believe I yawned. I didn't get enough sleep.
Let's see here. Like I said, guys, I'm going to skip the stuff that's actually about the underlying facts. Mr. K saying, since I was involved, is Monty's random spriggery he sends you a violation at all? Well, no. I mean, if you're talking about what happened when I was on streaming and he called in and all that, no, that all happened before the lawsuit. And him being out here contacting me, I mean, if I was his attorney, I'd say leave everybody alone. That would probably be the smarter option to do things. And I don't know if this is a discussion Monty and his attorney have had. But yeah, I mean, there is something to be said about that. That doesn't ultimately mean this is sanctioned. It's not problematic conduct, unethical, sanctionable, or, oh my God, pearl clutching conduct. I wouldn't be worried about it like that, guys. So, X-Nun says Jim never said what Nick did. I know, but I just think the idea of Jim being coming into court would be great. Oh. Unhung Hero for $2 says Jim would have too much fun with that if he was. I know, I can see Jim coming in, like, riding in his wheelchair, and he's got, like, a T-shirt cannon loaded with hats, and he's just choo-choo, 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 all over the courtroom.
Oh, Sean.
That would be so
It's
funny
so
just
funny.
thinking about it.
Cracks me up.
And if he does show up, I can see Ralph show, like, everybody shows up. Ralph shows up, half the sector's there. Ralph says, I'll put you up in the guest room. All right. Let me see here, trying to catch up. Let me see. Yes, I know. I brought it up. Let's see here. Monty and all in the same chat. What a day. I know. What a day. It's a salad days chat. Salad days. Off license says Sean don't like to intimidate you. Nobody's intimidating me. I just think I should be proper and fair to both sides. So that's why I'm stepping back. I'm talking about the case. Because the facts are what they are. Saved by Pope Bracket saying, is it wise to even restream it and answer questions? I mean, I can answer questions about the fact, like me commenting on whether or not the right law applies in the situation, I don't think really affects my bias saying, well, I mean, like I said, there's a fair argument that this Colorado law does apply because, 99 times out of 100, it would be the place you're applying it in. That said, though, there is the idea, I'm suing you where you live. You got to deal with it. I think there's a fair argument there. I think some of the arguments raised, and you hear them talking about different tests and distinctions. A lot of that's Minnesota law, so I don't really know it. But I mean, I don't see how that changes my opinion. You can't claim I'm biased because I commented on the choice of law.
I hope not. I hope not, but I don't know.
Popcorn says, how on earth am I a witness? Because I was on stream with Nick when he said these things. Some of these things. I was actually on a stream with him, like here on StreamYard. I was in a room with him when he did that. So, let me see here. Winning Reality. Hey, I just saw your
I don't know.
I just saw your message in Discord. Sorry, I didn't get to it sooner. I didn't see it. But for $20, thank you. It's saying, thanks for letting me snipe, bro. I usually have the Zoom link for these, but didn't get this one in time. Your take is that Nick should have set up and mine shouldn't have been there. So justice maybe served as it should. Who knows? That's your opinion to have there. That's your opinion to have there. But thank you for the super chat. Yeah, I just saw that.
I think it might have been better on Nick in the short term if he hadn't said what he said.
Yeah, guys, we actually, in a couple of minutes, I'm probably going to wrap this up and we're going to watch some of that Hannah Reed case because it's day 5 and they haven't gotten too far yet.
I'll actually have to call it a day here because I got to shut down this computer.
Amon saying, go to the filings now. I don't want to get into the filings really.
So,
just because I feel like then you start talking about them and I don't feel like that. Like I said, guys, I don't feel like I should be doing that.